you wish, Your Honor, but I can confirm that we have some very technical folks on our end that have been trying to access the documents for the same purpose of moving this case forward. And it's been difficult. And so now we're put in the position of trying to take what has been produced and get an e-vendor involved, which is going to cost more money, of course, but we're getting an e-vendor involved, just as Mr. Diller is, to try to better access these documents. And then I would just say to, from what I have been able to see with the 518 videos, they're not, as far as I can tell, categorized in any way. My operations manager has told me that we can see that there's driveways, there's Ring doorbells, there's some body cams, there's cars backing up, which I can presume is Ms. Reed's. There's some audio files that sound like they're coming from dispatch, but nothing is date and time stamped. We're having a difficulty sort of trying to weed through it and discern what is relevant and what is not relevant from those videos. And then with respect to the folders that I believe Mr. Rosenberg has referenced, we're having a hard time opening those as well. They seem to be either corrupted or not in a proper archive format, to the best I understand what my technical people have told me. So I can just say, Your Honor, we are having some similar difficulties that we would love to get past with the cooperation of all parties in the court.
What depositions, if any, have been noticed by CNC?
We have not noticed depositions for two reasons. One, there will probably be very few from us, Your Honor. But two, we want to only notice depositions that we truly intend to take and are not duplicative of other parties. So we have talked with Mr. Diller and conferred with him on the short list of folks that we would anticipate that we would like to depose. And frankly, we've also talked to counsel for Waterfall about this. And then, of course, Mr. Diller has talked to me about some of the folks at McCarthy's that he would be looking to depose. But on both sides, it's a relatively short list, Your Honor. And as soon as we get through these documents, we are in a position to proceed with that type of discovery and with depositions.
Thank you. Why don't I hear from Waterfall, please?
Thank you, Your Honor. David Hassett. Judge, we have responded to the plaintiff's discovery, interrogatory answers, and document responses. We've also propounded discovery to the plaintiff and to the individual plaintiffs identified in the suit. That discovery is outstanding by agreement. As to the documents produced, we also have not yet commenced deposition. The documents that we have gotten through the discovery to date, we've been working through and expending efforts to get to the documents, understand the documents. We've had some challenges, but we've been trying to implement some workarounds, but that is not completed yet. And we also have a discovery e-vendor that will be assisting us in the pursuit of getting our arms around all those documents. We have been in discussions with Attorney Diller and Attorney Smith about the depositions we would be taking. There are obviously some overlap with the depositions that the Reed team would be taking and the O'Keefe team, but that the separate depositions of patrons or witnesses, we conferred about those. I agree it's a relatively short list, and the hope was for us to review the documents before starting that process.
Attorney Hassett, do the challenges you have encountered include the inability to access the documents produced?
Not all of them, Your Honor. We have been able to access documents, but we haven't been able to access all the documents. For instance, some of the folders that were described by Mr. Rosenberg and Mr. Diller, they will open up and they'll be blank, there'll be nothing in there, or they're corrupted. I believe we've had some communication with Mr. Rosenberg's office about some access to files and our own IT support internally. So what I would say, Your Honor, based on 990,000 pages, there is a percentage that we haven't accessed properly or completely. One thing I will also add is that there is a load file that we recently received that has metadata. It appears that will assist in terms of accessing documents or files that we've struggled with. So that's something that we intend to do next.
When did you receive that?
I think it was in the last week, Your Honor.
Okay.
Your Honor,
Thank you.
can I just note, Your Honor, I haven't heard from either of the two bars about these issues. I'm happy to work with them, just like I've been working with Mr. Diller, to have these documents assist with whatever technical issue that they're having. I just haven't been aware of those yet. So if they reach out to me, I'm again happy to help with that. But I understand there is a lot of paper here, and there is a need for e-discovery vendors because primarily the plaintiffs have asked for all of these million pages of documents. So I understand why all of the parties are explaining the need to access things in order to go forward and proceed even further with discovery. But I just want to be clear, to the extent there's any technological issue, parties need to reach out to us and let us resolve those, which we will do.
But the common theme seems to be that they're all having some difficulty.
Well, I agree with you based on what I just heard, Your Honor, but I'm not aware of that until just this moment. The only party I've conferred with about these issues is Mr. Diller, and we've been talking about it for, I think we'll agree we've been talking about it for a month or more. So I'm more than happy to do that, and I don't know what the issue is from the other defendant's perspective. I know from Mr. Diller's consultant what the issue is now, which I believe we've resolved, and he's said he should be able to know that shortly. So I would suggest I'm happy to speak with anyone that needs to in the next couple days to address any technological issues that are remaining.
So, Attorney Rosenberg, in November, Attorney Waters indicated that the Reed team had sent out between 10 and 12 subpoenas.
That's correct,
And it appears you've resolved, at least for now, issues relative to Sergeant Good, Mr. Proctor, as well as the Norfolk County District Attorney's Office. That's 3. Who were the other parties that notices of deposition went out?
So there's only been one. There's only been one.
Well, Attorney Waters indicated between 10 and 12. I've just addressed 3 of them, so that leaves 7 to 9. So you said there's only been those 3?
No. So the question to Attorney Waters at the last hearing was subpoenas. Those were primarily document subpoenas. The deposition subpoena and the notice of deposition, which is the only deposition that's scheduled thus far in this case, is our deposition of Michael Proctor, which we've finally locked in with everyone's availability, all parties, counsel, and Mr. Proctor and his counsel's availability. And that'll be going forward in April. We have not yet scheduled other depositions, but we from the Reed side plan to do so very shortly. And as you can tell, obviously the discovery from our end is going to be primarily third-party discovery. So there will be additional depositions put on the calendar soon, as soon as we're able to coordinate schedules, which has obviously been daunting in this case.
So just so I understand, what subpoenas have been sent out?
So we've sent 2 subpoenas to Michael Proctor because there was additional information that became we became aware of. We've sent a subpoena to the town of Canton. We sent a subpoena to the Boston Police Department. We sent a subpoena to the Massachusetts State Police, sent a subpoena to Sergeant Good, as Your Honor said. We sent a subpoena to, I don't know if I said the District Attorney's Office, but both us and the plaintiff sent subpoenas to the District Attorney's Office. We sent a subpoena to Mr. Proctor's prior attorney in connection with his appeal, just relating to this one particular issue that is relevant to the District Attorney's Office subpoena. There might be 1 or 2 I'm not thinking of off the top of my head, but That's the bulk of them thus far.
When did the subpoena go to the town of Canton?
The subpoena to the town of Canton went, off the top of my head, July or August of 2025, I think.
And have you received a response?
We've received documents. We are currently discussing with their counsel additional documents that we had been under the impression they didn't have, but now I believe they may actually have. So I'm in the process of a 9C conference with their counsel to determine if they will produce these additional documents that they should produce from our perspective.
When did the subpoena to the Boston Police Department go out?
Roughly the same time. So the first subpoenas we sent all around the same time was the town of Canton, the Massachusetts State Police, Michael Proctor, and the Boston Police Department. Those were all July to August. And then, as I said, we followed up with a second subpoena to Mr. Proctor, approximately September of 2025.
Would you agree that 8 months to resolve issues from subpoenas might be a little unreasonable?
I certainly would, Your Honor, but here's what's been happening in this case. Every time we serve a deposition, we serve a subpoena, we either are ignored by the recipient of the subpoena, as happened with Sergeant Good, happened with Mr. Proctor, happened with, at first, the Boston Police Department. Then we're presented with objections and a refusal to produce documents. We try to confer. These are government entities in large part that we're discussing right now. And it takes time to even get people on the phone. We get them on the phone. There's continued refusal to produce documents. We attempt to confer as we're required to under 9C to try and get documents without burdening the court with motions to compel. We then, in some instances, for example, the district attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified by the district attorney's office in the Commonwealth, documents that may be evidence of bias. They did that pursuant to a court order in other criminal cases. They then returned that phone to Mr. Proctor. We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena because the district attorney's office told us they wouldn't give it to us because it had to come from him directly. As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain those documents from Mr. Proctor. So we had to go back to the district attorney's office and tell the district attorney's office we need it from them. I then engaged for 2.5 months negotiating an agreement with the district attorney's office, which would only give us these relevant documents, despite the civil rules, would only give them to us with onerous restrictions that are unusual if never occur in civil cases like this. But we agreed to that because we need to get the documents. So I 100% agree with you. When we've sent out subpoenas, we have not gotten the responses that we should have gotten under the rules and the law. But we've had to put in a lot of extra time and effort and resources to getting these entities to produce documents. The state police still haven't produced documents. I was under the impression they'd been reviewing them for months, just found out from their counsel that they had made little to no progress, and I needed to again threaten a motion to compel in order for them to agree to produce, to do what they have to do. So I agree with you, Your Honor. We shouldn't have to wait that long.
But here we are in February and we're not any further along. I detect a little frustration from you, Attorney Rosenberg, but why don't you utilize the court to maybe relieve that frustration? If you have issues that you need to bring in front of the court as far as a motion to compel, let's get them filed. This case...
Can I just be clear?
It needs to start moving along.
Well, I need to be clear with Your Honor, and I'm hearing you don't want us to confer with these parties and continue to drag out those conversations. The rules, I believe, would require me to do that, and I can't just come into court asking for a motion. But if you'd prefer us to handle it this way, when we get non-compliance from a subpoena recipient, I'm happy to do that. I just am sensitive to the requirements of 9C.
I'm not suggesting you ignore any of the rules. I'm suggesting you avail yourself of the opportunity to use them. And I'm simply suggesting that the length of time that it has taken to resolve issues that shouldn't really be issues appears to me to be excessive. So we have to figure out a way to bring them to a head.
Well, I agree with you, Your Honor. It's just, it's excessive from the recipients of the subpoenas. We're certainly not delaying anything. We've been demanding documents since July, and we've been out there taking discovery and trying to move the case along, which is what we intend to continue to do. So as soon as I have a situation where the recipient of a subpoena is not engaging in good faith conference under 9C, we've been filing motions, and we've had, I believe, 3 or 4 before, Your Honor. Then the parties who have received the subpoenas seem to all of a sudden be more willing to comply just before we have hearings with the court. And so we are using those tools, and we'll continue to do so.
Anything else?
Not for me, Your Honor.
Okay, so why don't we all plan to get together next Thursday at 4 o'clock in the same fashion? And Attorney Diller can report on his success or lack of success in seeking to access the documents. And it'll give you and Attorney Diller a further opportunity to talk about his concerns about categorization or identification of the documents that are produced. And then I'd ask all the parties to submit at this point in time the intended depositions. And I understand that may change, but I want to know who people intend on deposing. Is there anyone that can't make it next Thursday at 4 o'clock? Hearing no response, we'll see everyone next Thursday. Thanks very much.
Your Honor, I have a question, though, about the request for the intended depositions. Are you looking for that to be a formal written disclosure, or is that something that we could show you in camera so as not to make public all the parties that we intend to depose?
You can share it to me in whatever fashion you want to.
Okay, thank you, Your Honor.
All right? Anyone else have any questions? Okay, thanks very much. We'll see everyone next Thursday.
Thank you, Your
Okay,
Honor.
so for the
Thank
record,
you.
Your Honor.
for the record, this matter is continued to February 12th, 2026 at 4 p.m. for further status, and that hearing will be held via Zoom.
And Attorney Rosenberg, still, because I want to have a clear record here, please, as I indicated earlier, provide the court with a copy of whatever you produce to Attorney Diller.
Okay, it'll come from Mr. Maravellis and Mr. Bell, my co-counsel. The production
Okay.
came from their office.
All right. Thank you.
Your Honor,
Thank you.
Your Honor,
Yes, sir.
with respect to production, who would you like me to coordinate with? Because our office will need to coordinate with somebody from the court with respect to e-discovery. We cannot just send you an email. It's a much more complex process that we've been involved in. We have an e-discovery vendor, and we would need somebody on the court side to be able to receive it. Otherwise, we can't just. You will not be able to receive it just via email. You'll need some type of technical capabilities to receive the actual documents. So we're happy to coordinate with somebody with the court if there's somebody you'd like to put us in touch with.
You can start with Assistant Clerk Donovan.
Okay.
Okay?
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you all.